within the exception of para 810 of the Indra Sahni's case, my lord, to qualify to be an exceptional circumstance to breach the rule of 50%. So, my lord, that discussion started from para 460. My lords had reached up to para 467, my lords. This is important, my lord, with reference to the arguments which are raised by the state in support of the legislation, that they intend to exactly do the same thing, my lord, that is to breach the rule of 50% laid down in Indra Sahni in para 809 and 810 with the use of quantifiable data which they say has been collected through, in the present case, the Mahajan Commission of 1983. So, my lord, para 467 quotes Nagaraj's judgment, para 123, and the last 3-4 lines were relevant, my lords, in the quoted portion. It is made clear, your lordships have it, my lords?
Yes, yes.
Yes, it is made clear that even if the state has compelling reasons, as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling or limit of 50% or obliterate the creamy layer or extend reservation indefinitely. The Constitution Bench in para 123 held that the provisions of Article 16(4)(a) is an enabling provision and the state is not bound to make reservation for scheduled castes and scheduled tribes in matters of promotion, and however, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class in inadequacy of representation. The above observation regarding quantifiable data was in relation to enabling power of the state to grant reservation in promotion to scheduled castes and scheduled tribes. It is further relevant to notice that in the last sentence of para 123 it is stated, it is made clear, then the same portion note that your lordships read above, the same part is repeated note. It is made clear that the 50% rule cannot be breached using quantifiable data. My lord, may turn over to page 470, para 470 notes.
Please repeat the para.
My lords, para 470 on the next page, my lord, 246. The Constitution, the bench thus in the above case clearly laid down that even reservation for promotion ceiling of 50% cannot be breached. The Commission has completely erred in understanding the ratio of the judgment when the Commission took the view that on the quantifiable data, ceiling of 50% can be breached. There is no such ratio laid down by this court in M. Nagaraj. Hence, the very basis of the Commission to proceed to examine the quantifiable data for exceeding the limit of 50% is unfounded. Para 326 of the report of the Commission contains the heading quantifiable data. It is useful to extract para 236, which is, my lord, the entire para is extracted. My lord, may skip over the earlier part and come to where the percentages are noted, my lords. 35.7, my lords have it. Thereafter, my lord. Percentage of all the reserved backward classes to be 48.6%. In the state of Madhya Pradesh, my lord, it is 48.08%. The percentage of other classes or the population who have not disclosed their caste is shown to be 15.7%. From the survey of the report, though it relates to rural area, the percentage of the existing backward classes, Maratha and Kunbi, who claim to be backward comes to 48.6% plus 35.7% equivalent to 84.3% of the total population. There is no dispute that large population of Maratha and Kunbi castes as well as existing backward classes are inhabitants of the rural areas. 48.6% population of the existing reserved category includes scheduled castes, scheduled tribes, and all backward classes have been identified as socially and educationally backward. The Maratha caste has been identified socially and educationally and economically backward in the Commission. So, as total 84.3% population can be said to be backward classes. Regarding the above noted quantifiable data, the Commission has recorded its reason for reservation under Article 15(4) and 64 in para 259. We extract, my lord, this is important, blocks. To sum up, this Commission has already found above on appreciation of evidence collected produced before it that 80 to 85% of the population in the state of Maharashtra is backward. According to the Commission, to accommodate the 80 to 85% backward population, which is ceiling of 50%, will be injustice to them, and as such it would frustrate the very purpose of the reservation policy arising out of Article 15 and 16 of the Constitution. In the considered opinion of the Commission, this is an extraordinary situation which has been mentioned in the second term of reference, and as required by Indira Sahni, 80 to 85% backward population adverted to above speaks about quantifiable contemporary data by Nagaraj. So this was the justification which was provided, my lords, that the quantifiable data is the extraordinary circumstance that the population is 80 to 85% of the OBC community, and therefore restricting reservation to 50% would not be proper, and hence treating the quantifiable data to be an extraordinary circumstance, it was recommended that higher reservation be provided. Then 473 minutes. It is clear that the entire basis of the commission to exceed 50% limit is that since the population of backward class is between 80 to 85%, reservation to them within the ceiling of 50% will be injustice to them. This is the conclusion, Lord, that the Honorable Supreme Court draws from the report. Then my lords may come to para 476 at the bottom. This court in several judgments has noticed that what can be the extraordinary situation as contemplated in para 810 in few other cases. We have referred to above three judge bench judgment in Union of India versus Rakesh Kumar, where the three judge bench held that exceptional case for 50% ceiling can be in regard to panchayats in scheduled areas. The above three judge bench has also been approved and reiterated by the Constitution bench of this court in K. Krishnamurthy. In the above cases, this court was examining the reservation in panchayats in the context of Part 9 of the Constitution. 50% ceiling principle was applied, but exception was noticed. In the above context, we also notice para 269 of the impugned judgment of the High Court, where the High Court has also come to the conclusion that the Maratha has made out a case of extraordinary situation within the meaning of para 810 of Indira Sahni case. The High Court in para 269 of the judgment made the following observations. My lord, this was the impugned order before the Honorable Supreme Court. We would curiously refer to the reports which would disclose that it is for the first time in the form of Gaikwad Commission, the quantifiable data has been collected, and in terms of Nagaraj, the quantifiable data inadequacy of representation are two key factors which would permit exceeding the reservation of 50% by the state. So this was the opinion of the High Court. The High Court has endorsed the opinion of the Commission that when the population of backward class is 85%, if they would get only 50%, it would not be valid. In para 275 of the impugned judgment, my lord, may just skip over the top part. In the last 4 lines, my lord, after referring to the data and reservation percentages, it says, my lord, therefore, my lords have it. Last 4 lines, my lords. Therefore, in terms of the population, yes, my lords. If we look at the figures, then the situation which emerges is that almost 85% of the population is of the backward classes, and to suggest that if 85% of the people are backward and they get only reservation of 50%, it would be travesty of justice. When we speak of equality, equality of status and opportunity, then whether this disparity would be referred to as achieving equality is the moot question. The situation of extraordinary circumstances, circumstances as set out, though by way of illustration in Indira Sahni, would thus get attracted, and the theme of the Indian Constitution to achieve equality can be attained. So this was the reasoning, my lord. Then my lord may have para 479. Again, in para 286 of the judgment, the High Court reiterated that extraordinary situations have been culled out by the report since backward class is 85%, Marathas being 30%. Treating the above to be extraordinary situation, the following observations have been made in para 286. Then the para 286 is reproduced. My lord may skip over that, my lords. That was to justify reservation to breach the limit, my lords. 280, my lords. From the above, it is clear that both the Commission and the High Court treated the extraordinary situations with regard to exceeding the 50% for granting separate reservation to Marathas. The fact that population of backward class is 85% and reservation limit is only 50%. The above extraordinary circumstances as opined by the Commission and approved by the High Court is not extraordinary situation as referred to in para 810 of Indira Sahni judgment. The Marathas are dominant and forward class and are in the mainstream of national life, which does not apply to us. The above situation is not an extraordinary situation contemplated by Indira Sahni judgment, and both the Commission and the High Court fell in error in accepting the above circumstances as extraordinary circumstances for exceeding the 50% limit. So it has been categorically held, my lords, whatever data can be collected with regard to backwardness or with regard to inadequacy of representation, not what to speak of proportionality, but even if it is inadequacy of representation, then such quantifiable data, my lord, cannot fall into the parameters of being within the extraordinary situation, my lords, as specified in para 810 of Indira Sahni.
Yes.
My lord, this has been further emphasized in para 482, my lords.